Yes.
I know if you've not said that's one.
Please swear your right hand, sir. You swear or.
Maybe I did.
Yourself. You have your right. Yeah. Place it flat. Okay, I need it way, really, look. Look, he's here, try this again. Ink it up.
And get up.
Place it
Also,
flat.
I'm making all kinds of mistakes.
Okay, that's much better. Let's do that one more time.
Wow.
And then do it by where next to it.
This one.
Much better. Thank you. Yeah.
All if you did, but it does. My perspective is more on. Oh, it looks like.
24 CR 350 is now called the state of Texas versus Christopher Henderson. You are Mr. Henderson, right? And you were here with Miss Minaldi, your attorney, and the state's attorney. There is a motion to revoke unadjudicated probation that was filed in October of last year. Are you familiar with it, sir?
Yes, sir.
We're going to be dealing with that today, okay? Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, Judge.
Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion states that on May 19th last year, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for unlawful possession of a firearm by a felon, a third-degree felony. Is that true?
Yes, sir.
Allegation 1 states you committed the offense of driving while intoxicated on or about August 6, 2025 in Jefferson County, Texas, which is a violation of condition 1 of your probation order, which states do not commit a crime, such as a DWI. Is that allegation true?
Yes, sir.
Are you pleading true today voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and a knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be found guilty and sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true in this motion to revoke probation. An agreement has been reached where you would be pleading true, your probation would be revoked, you would be found guilty and sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. In this case, among other things, State's Exhibit 1 states that you are giving up all rights of appeal if I follow this agreement. I will do that.
Yes, sir.
Anything else to add? Pre-sentence report is waived or
Yes, Judge.
anything from probation to add? Okay, if nothing further, I'm going to find that Mr. Henderson, you have today pleaded true voluntarily, knowingly, intelligently to allegation 1, committing the offense of driving while intoxicated while on probation. And that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Thus, your probation is hereby revoked. Earlier in this case, you had pleaded guilty to the underlying offense of unlawful possession of a firearm by a felon voluntarily, knowingly, intelligently. There was sufficient evidence of your guilty plea at that time from State's Exhibit 1 made at your plea hearing. to support your guilty plea to find you guilty beyond a reasonable doubt. Now that your probation is revoked, I now find you guilty beyond a reasonable doubt of this underlying offense of a third-degree felony of unlawful possession of a firearm by a felon that you were indicted for originally in this cause number 24 CR 350. I hereby find you guilty beyond a reasonable doubt of that third-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add by anybody?
No, sir.
All- That is all. Thank you.
Celebration.
Jaamos Maxi Mouton,
Judge, I believe there is a motion for competency evaluation on file.
what do you want to do today?
I would like for that motion to be signed for him to be evaluated, Judge. I saw him again yesterday and he was still speaking as if there were issues.
I'm happy to sign one, but I don't know where that would be.
Thought office had sent it over. I'm double checking on that, but that's the only update I have for that one.
I mean, I don't see one, but if you just email it to me, I can get it from the judge.
I will be done. It will be done when it gets to you.
Thank you, Judge.
Eric Norman,
A plea, Judge.
and nothing but a plea, so help you God.
Okay.
Is this 4 cases?
Yes, Judge.
How you doing?
One is a motion for probation.
Norman?
3 new cases. They'll all be handled together.
Ma'am?
They'll all be handled together.
Okay, he's pleading all.
Yes.
Yes, ma'am.
Your right now,
What is that?
You're making me work really hard today.
much larger than that. I got police.
Don't you like whenever?
Yes, I do.
Right there, yeah.
Look,
Okay, one more time.
it's like going Briar
I
Rapids.
think she's the one keeping you afloat.
Yeah, keep giving it to me. Come on. I love it.
I just emailed it to you, Lacey.
Do what?
I just emailed that.
Okay, yeah, I'll print it out, put it in front of the judge.
All right.
Facility.
You or Eric Lee Normans?
Yes, sir.
There are 4 cases here, so hang in there with us. It's going to take a little bit of time. Okay, one at a time. Yes. One, 50, 51, 52, 2349, 49. We're going to take that one up first. Okay. And then we'll go from there.
Rest of them are all the same, I believe.
20-34949 is called the state of Texas. Eric Lee Norman Jr. That's you, sir.
Yes, sir.
Present with your attorney. There are 4 cases here of these motions, the motion to revoke probation in 34949 and the new indictments, it looks like, in cause numbers 26 CR 350, 351, 352.
Yes, sir.
And we proceed fashion.
Yes, Judge.
Okay. 34949. In summary, this states that on November 2nd, 2022, in this court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of unlawful possession of a firearm by a felon. Is that true, sir?
Yes, sir.
And raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. And again, is that true, what I just stated about this prior probation in this case, 10 years deferred
Yes, sir.
probation? All right. One states, is that
Yeah.
is that part of it?
It is
One of-
one of the new
Which,
cases
which is it?
that I,
It is 350. It's November 4th.
Number one, allegation states you committed the offense of theft on or about November 4th, 2025 in Jefferson County, Texas, which is a violation of condition one of your deferred or unadjudicated probation orders. And that case is what is part of this new indictment 26 CR 350, the state jail felony of theft. Is all of that true, sir?
Yes, sir.
Are you pleading true to this allegation voluntarily and because it is true as it is alleged?
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked in this case. And you can now be found guilty beyond a reasonable doubt of the underlying offense of a third-degree felony of unlawful possession of a firearm by a felon and sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing all of that, do you insist on pleading true to?
Yes, sir.
I find you are pleading true in the case voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of entering your plea.
Yes, sir.
This is your signature. It looks like a line that goes across
Yes,
the
sir.
horizontal.
Yes, sir. I usually sign like
That's the way you
that.
sign.
Yes, sir.
An agreement's been reached where your probation would be revoked. You would be found guilty, sentenced to 6 years in prison for this third degree felony. Is that your understanding of the agreement? And this sentence would run concurrently with these other cases we're about to deal with. Is
Yes,
all
sir.
of that true?
Yes, sir.
If I follow this agreement, 6 years in prison, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked here as States Exhibit 1. Did you sign that document voluntarily
Yes, sir.
in your special signature?
Yes, sir.
Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence
objection.
without objection admitted. This states if I follow the agreement, you have no right of appeal. I'm going to do that. Do you understand?
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived on this.
yes, Judge.
I'm going to find, if nothing further, Mr. Norman, you have pleaded true voluntarily, knowingly, intelligently to allegation 1 of this motion to revoke probation filed on January 2nd, 2026, by committing the offense of theft on or about November 4th, 2025 in violation of condition 1 of your probation order, which is don't commit another offense while on probation. That is enough to support this motion to revoke probation by preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked because of this violation of probation. Earlier in this case, when we placed you on deferred or unadjudicated probation for 10 years, you had pleaded guilty to the third degree felony of unlawful possession of a firearm by a felon voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. But we postponed any finding of guilt so long as you followed the conditions of probation. Since you have failed to do that, based upon this hearing now today, your probation is hereby revoked. And I hereby now find you guilty of that previous offense. Once again, I'm reaffirming the earlier finding that there was sufficient evidence support your guilty plea to find you guilty beyond a reasonable doubt. And I hereby now find you guilty beyond a reasonable doubt of that earlier case. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years to run concurrently with other cases. Do you understand what's happened in this case?
Yes, sir.
There's that. All right, we've got these three other cases, cause numbers 26 CR 350, 351, and 352, which are all state jail felony thefts in each of these cases. Are these enhanced by prior convictions?
That's correct.
Is this going to be 6 years?
Yes.
Yes, sir.
Confinement in prison
These are all
for
gonna
these
be-
three state jail felonies?
Yes, sir.
To run concurrently?
Correct.
Okay. Can we take these up together then?
Yes, Judge.
All right. Does the defendant waive formal readings of these indictments and arraignments in these three cases? Can we proceed in summary?
Yes, Judge.
In 26 CR 350, this hereby states that on or about November 4th, 2025 in Jefferson County, Texas, you committed the offense of theft, and it looks like colognes, taking colognes and perfumes. This was of a value of less than $2,500 from looks like Walgreens as the store. Do you understand what your charge did?
Yes, sir.
Yeah, that would be less than a state jail felony, except paragraph 2 goes on to you have 1, 2, 3, 4 prior convictions of thefts out of Hardin County and this criminal district court of Jefferson County, Texas. So paragraphs 1 and 2, because of the prior convictions of thefts, will constitute a state jail felony. Do you understand if that is paragraphs 1 and 2 are found true, reasonable doubt?
Yes, sir.
But it goes on. You have 2 more prior convictions here. In paragraph 3, it is alleged that honor, good. I'm seeing the same date. It was from a court in this court, from a case in this court. It's also on the same date as paragraph 2 prior convictions, but those are different convictions.
Right.
All right.
Well, paragraph 2 would be to make it a state jail.
Well, it's a theft.
Right.
It's a theft. They can't, the same one can't be used again,
Correct.
but it's not. It's a different crime. You were convicted of more than one offense on one day here in this court.
Yes,
So
sir.
paragraph 3 goes on to state that on January 12th, 2018, when you were convicted of theft as well, you were also convicted of burglary of a building, a state jail felony in cause number 13-18271. And in paragraph 4, it goes on to allege that on March 2nd, 2022, in cause number F as in Frank 2251442-W as in William, in the 363rd District Court of Dallas County, Texas, you were convicted of the state jail felony of unlawful possession of fraudulent use or possession of identifying information. So those 2 state jail felonies, along with paragraphs 1 and 2 state jail felony, those 2 prior state jail felonies will mean that in this case, you are facing state jail felony, but you are going to be punished as though it were a 3rd-degree felony because of the prior convictions, which means you are looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
These aren't, today's kind of like a bar exam. This one is, we've got a lot of complex issues here we're dealing with. So it's a state jail felony, which carries with it generally up to 2 years in the state jail, but because of the prior convictions, you are looking at punishment range as though it were a 3rd-degree felony that we discussed
Judge, in
This-
350, she put down felony seconds. I put 2 to 20, and it should be, she should have put a third, and then it'd be 2 to 10. So if you'd like me to change it, I'll change it. Or
No, I'd rather use this pen that never works.
that's why I was going to offer to do it for you, Jeff.
Do is put, yeah, it's up wrong up at the top too.
Moving so fast.
Yeah.
I'm gonna use Astros. I just love Astros. They look like a snowflake.
So Jeff can go all there. So, question. I have a pen. You can spill a pen time as well as this one. Something. Sorry, I'm thinking about maybe this. There. I have to step away every now and then from the camera, so clear on the back of my head doesn't blind everything.
Okay, you're looking at state jail felony punished as though it were third degree felony. So no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached where you would be sentenced to 6 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to paragraph 1? Committing the offense of theft on or about November 4th, 2025 in Jefferson County, Texas, guilty or not guilty? So
Guilty.
you're pleading guilty voluntarily and because you are guilty.
Yes, sir.
Paragraph 2, which alleges these 4 prior theft convictions previously in other courts. Are those allegations all true and correct as they are alleged? And are you pleading true and correct to that voluntarily?
Yes, sir.
And finally, paragraphs 3 and 4, those the burglary of a building state jail conviction in this court in 2018 and the fraudulent use or possession of identifying information, a state jail felony in the 363rd District Court of Dallas County, Texas. In paragraphs 3 and 4, alleging those prior convictions. Are those true and correct?
Yes,
And
sir.
are you pleading true and correct to that voluntarily?
Yes, sir.
All of that turns what would have been a misdemeanor theft
Right.
to a state jail felony in paragraphs 1 and 2 because of the prior convictions of thefts, and punished though as though it were a third degree felony due to the prior convictions in paragraphs 3 and 4, the burglary of a building, state jail, and the fraudulent use of identifying information. Correct. All of that, you understand?
Yes, sir.
And the agreement is that you would be sentenced to 6 years in prison. If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No, sir.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. Read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports waived in this.
Yes, Judge.
I'm going to follow this agreement and find you're pleading guilty and true to paragraphs 1, 2, and 3 of this indictment. Voluntarily, knowingly, intelligently. This constitutes a state jail felony based upon paragraphs 1 and 2 of the indictment, and punishment as a third degree felony based upon paragraphs 3 and 4 of those prior convictions. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to a confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. This, though, for the record, is a state jail felony, but it is punished as though it were a third degree felony because of all the prior convictions from paragraphs 2, 3, and 4 of the indictment. Do you understand what has happened today, sir?
Yes, sir.
Okay, there are two other cases, 26 CR 351 and 26 CR 352. I think we're going to go quicker now that these two cases will be handled similarly to the preceding case 350. Does the defendant, and can we collectively do these
Yes.
together? And Kezi waive formal readings of the indictments and arraignments. We can proceed in summary.
Yes, Judge.
In these two cases, Mr. Norman in 26-351 and 26 CR 352, these in paragraph 1 in each case similarly allege thefts. In 351, on or about November 22nd, 2025 in Jefferson County, Texas, you committed the offense of theft. And in 352, on or about November 14th, 2025 in Jefferson County, Texas, you committed the offense of theft. Do you understand what you're charged with in each case?
Yes, sir.
In each case, paragraph 2 goes on to allege that you have four prior convictions of thefts. April 30th, 2014, County, Texas. September 30th, 2016, in this criminal district court. Thefts. 2018, January 12th, 2018, this criminal district court. Theft. And finally, January 12th, 2018, this criminal district court theft. Those are 4 thefts. 2 or more in that paragraph then constitute paragraphs 1 and 2 to be a state jail felony. Do you understand?
Yes, sir.
And finally, paragraphs 3 and 4 similarly allege that you have a prior state jail conviction of burglary of a building, January 12th, 2018, out of this criminal district court. And finally, in paragraph 4, you also have a conviction of fraudulent use of possession of identifying information, a state jail felony, convicted on or about March 2nd, 2022, in the 363rd District Court of Dallas County, Texas. And thus, this state jail felony in paragraphs 1 and 2 then becomes punished, though, as though it were a third-degree felony because of paragraphs 3 and 4. So, do you understand what you're charged with in each of these two cases?
Yes, sir.
And what the punishment ranges are?
Yes, sir.
Similar. They're similar.
Yes, sir.
And in each of these cases, that's not right.
We'll get rid of the 50. Yes. Know the name.
In each of these cases, you understand the similar punishment ranges of no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000, even though it's a state jail felony. Because of the prior convictions, it's punished as though it were a third-degree felony. And the agreement is that you would be pleading guilty, sentenced to 6 years imprisonment on each case to run concurrently with other cases. Is that your understanding of the plan?
Yes, sir.
If I follow all of this, you have no right of appeal in each of your cases. Do you understand?
Yes, sir.
So how do you plead in each of these cases? In paragraphs 1, 2, 3, and 4, guilty and true respectively
Yes,
to
sir.
those allegations? Are you pleading guilty and true in each of these cases to all 4 paragraphs, sets of paragraphs in the indictment voluntarily, knowingly, intelligently, and because those allegations are true as they are alleged?
Yes, sir.
Sure, got all this. Almost.
Yes, sir.
What day is it?
The 30th,
Oh,
Monday.
same day we started.
I can't believe March is almost over.
It might not be over if we don't get out of this hearing, I'll tell you. I gotta change this up here, take one more, this last felony second. And finally, in 26 CR 351, I want to make sure that the record shows that you were pleading guilty in each of these four, and true respectively in each of these four paragraphs, which similarly as the prior cases allege a theft in paragraph 1 and 2 or more prior theft convictions in paragraph 2, thus turning paragraphs 1 and 2 into a state jail felony. Is all of that true and correct, sir?
Yes, sir.
And then paragraphs 3 and 4 constitute prior convictions of state jail felonies. And those turn that state jail felony because of the prior convictions in paragraphs 3 and 4 to punishment as though it were a third degree felony. So again, it's a state jail felony in the books, but punished as though it were a third degree felony. Do you understand?
Yes, ma'am. Yes, sir.
So how do you plead in paragraph 1 to that theft, guilty or not guilty, on or about November 22nd, 2025 in Jefferson County, Texas?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
Paragraph 2, those prior convictions that we had talked about from Hardin County and then this criminal district court, 4 convictions of thefts. Is that true and correct as it is alleged?
Yes,
And
sir.
are you pleading true and correct to that voluntarily?
Yes, sir.
Then that would make paragraphs 1 and 2 a state jail felony. But these prior convictions of a burglary out of this court and that fraudulent use and possession of identifying information out of Dallas County, those prior convictions, are those true and correct as they are alleged?
Yes, sir.
And you're pleading true and correct to that voluntarily.
Yes, sir.
Thus, your punishment range because of that then gets bumped up from a state jail felony to third degree felony punishment. I'm going to show you what's marked as State's Exhibit 1 in this case. I'm going to ask you, did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. Again, this states in all of these cases, you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read, or you've read them, or they've been read to you. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your attorney in all of these cases. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report waived in all of these cases. Now,
Yes, Judge.
all right, I'm going to find in 351 and 352, these 2 cases, you have pleaded guilty to paragraphs 1, 2, 3, and 4. and pleaded guilty in paragraph 1 and true to paragraphs 2, 3, and 4. You are doing that voluntarily, knowingly, intelligently. That is enough to grant this motion, that is enough to find you guilty in each of these indictments beyond a reasonable doubt. But paragraphs 1, which is theft, and paragraph 2 together, I find you guilty beyond a reasonable doubt. And that constitutes a state jail felony of theft. And in each of these cases, paragraphs 3 and 4 are proven true. Those are prior convictions of thefts, which bumps the punishment range of the state jail felony. It's a state jail felony, but it's punished as though it were a third-degree felony, up to 10 years imprisonment. I find you guilty of this state jail felony in each case. I'm sentencing you under this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. And all of these cases shall run concurrently. Do you understand what has happened in these 4 matters, sir?
Yes, sir.
Anything else?
No,
That is all. Thank you.
Staggering or something. Sure.
Okay.
Thank you. You go get this.
There's no easy way on that one.
It's just a lot.
Ashley Presley?
Judge, if I could have 2 weeks on her, I just need to work through a couple of things. And speak to Kenesha a little more about the case, see if we can have a direction on it.
26 CR 65, 2 weeks.
Yes, Judge.
Granted, thank you. And then there's David Wiggins.
Judge, I have filed a motion to withdraw on that case. He is. It's a motion to revoke probation, but he's very hostile with me whenever I try to speak to him. He speaks to me in a very.
Should we bring him out? Let's bring him
What are you
out.
gonna do, Judge?
Wiggins. Well, I mean, we can do this forever. But I'm not gonna let him do it.
Just given the communication barrier, I just.
Well, he's gonna do this to everybody,
And I don't know.
theoretically.
I don't know if it's. Me specifically, or if it will be.
Come on
different
out.
with-
23 CR 1479 is called David Sinclair Wiggins. That's you, sir? You're Mr. Wiggins? You're charged here. There's a second amended motion to revoke probation that's been filed. And as of October 17th, 2025. These things essentially allege you failed to report to the probation office, it looks like in most of this, and failed to immediately report change of address. And then you're behind in fees.
And Judge, I have this paperwork as well,
What is this?
just in case you need it.
Ms. Minaldi, here's one of my court officials. She's a public defender. Are you having problems with this lady? She says you're rude to her.
Go through the without divorce.
I don't put up with that. If you are rude to her, I can hold you in contempt and add some more problems here, which I don't want to do. But can you be civil with her and act like a gentleman? She has filed a motion to withdraw and she never does that. But I'm not going to tolerate rudeness. And she's a very nice lady and she helps her people. She works very hard for the people she represents. But she's somebody I appointed. And when you insult her, you insult me. I would like y'all to try to work this thing out if possible, but I want to know immediately if he is rude or abusive in any way to you. I'm going to hold this motion. I'm going to take your word right now that you can be civil and a gentleman. And this is your life. She's helping you. She tries to help in all cases. Then you are looking at up to 10 years in prison here, sir. You've got a lot. You don't need to make enemies with the people who are trying to help you. Would you agree? What are we going to do with this?
Judge, I don't know, I wasn't able to have a meaningful conversation about his options with him yesterday. There's an offer on the table,
All right.
if you would like to
Would
have
you-
discussions about it today, I don't mind stepping in the back
All
and
right.
trying to speak
All
with
right.
them.
Let's try to see where this is heading. You have, sir, these are 8 violations, but they're essentially, he just didn't report. Well, if you walk off the job, you get fired. You got to report. Probation is all, if you can't do anything, you've got to report or else you're not being supervised. And that's what probation is all about. And I mean, you could commit crimes and those are serious, but if you're not showing up for work or probation, you're not on probation. You're on your own probation, which isn't the way it works. I lose track of supervision over you, but she is the person who's going to guide you through this problem that you've gotten into. It's like a minefield you've fallen into, and your probation, like I said, you're looking at up to 10 years in prison here. So you've got to negotiate through this problem responsibly, which means working nicely with the person who is your lifeline. Can you do that? And promise, if I find out, she's a very honest lady. She never files these motions. She would only do it if she felt that you had not treated her properly. And I'm going to trust the way she thinks. Fix this mess. But don't hesitate to let me know if there's a problem.
Okay,
And then
we're gonna step in the back,
we'll do it.
Judge, and see if we can.
Okay, let me deal
You'll
with
just
Mr.
give me
Burbank's case.
15 minutes.
Thank you. Okay. Mr. Burbank, come on up. Jeremy Johnson,
Yeah, sure.
what are we going to do on that?
They'll file, the bond, and they're one. And then I have another little, yeah. I'll get some collective record.
Okay. Dennis, we need Jeremy Johnson, please. Here's this. Thank you. That is Jeremy Johnson, that's you? Come on up. 25 CR 1907. You're charged, charged with a 2nd-degree felony of aggravated assault with a deadly weapon, but that's not the ending of that story, is it? You got 1, 2, 3, 4, 5 prior convictions alleged. And if this is all found true, if you're convicted of the 2nd-degree felony, then those are 2001. That's the same time, isn't it? Wow. I don't remember that. I remember something like that.
Judge, you're gonna have to speak up.
What'd you say?
Exactly. He
You're,
doesn't have his hearing.
you're looking at a 2nd-degree felony. Can you hear me? Well, what am I supposed to do? Can you hear me?
No, yeah,
Okay, you're looking at, because of your prior convictions. I don't normally use a megaphone like this, but the man has a hearing issue and he's not wearing his hearing aid. You're looking at 1st-degree felony punishment. You're looking at up to life imprisonment. Do you understand?
yes, sir.
Serious. What's that?
I'd ask you to please take a look at the bond, Judge.
What is the bond right now?
$300,000 plus a GPS device.
I'm sorry, is 100,000?
$300,000 plus a GPS device.
Let me look at the probable cause affidavit. Do you have a public safety report by any chance?
Judge. I didn't get noticed, but I'm okay. I'm prepared to go forward. I didn't get noticed. See notice. I'm serious. I'm looking. I would tell.
Your office.
Well, it's not in, policy system. Okay, I'll
No.
fine.
It was filed in.
We didn't receive this. But it's fine.
Well, what I do know is this, I've looked at the probable cause affidavit here, which is obviously charging the defendant with aggravated assault with a deadly weapon, namely a firearm.
I think it was a pellet gun, Judge.
I don't know. It says a firearm. And in the probable cause, it says a firearm. Doesn't say what it is. I don't know, but this is at about midnight, it looks like. And the is moving around here at this apartment. Or it's a rental property here in Beaumont.
It was a residence.
Residence, it's not clear what it is, but you've got photographs and video here of the defendant. The problem is this is at midnight and he's got 1, 2, 3, 4, 5 prior burglary of habitation convictions in paragraphs 2, 3, 4, 5, and 6 in out of this court.
Judge, I believe it's 6
What year was it?
priors.
Yeah.
1, 2, 3, 4, 5, 6.
That was a long time ago.
Yeah. 1, 2, 3, 4, 5, 6 prior convictions in 2001. Yeah.
And I questioned the attorney back then, but it must have been a plea deal for all those at the same time. But I don't believe that he's really been in any.
What was his sentence for those?
10 years.
10 years. Oh, okay. All right. Then here at midnight, you can imagine, he's alleged to be lurking around somebody's residence at midnight. And did he have a firearm? Is it showing? He's alleged to have a firearm, a deadly weapon, namely a firearm.
It was a.
Why wouldn't he charge with felon in possession of a firearm? Also,
It's a pellet gun.
well, I know you say that. That's not what it says. Have you seen the probable cause? It says a firearm.
I kind of know it's a pellet gun.
All right. Well, nonetheless, it's capable of causing serious bodily injury or death. So it's a deadly weapon, even though it may be a pellet gun. Doesn't have to be an AK-47. It can anything that can cause serious bodily injury or death, which a pellet gun can, shoot your eye out, which is serious bodily injury to anybody who's had their eye shot out by a pellet gun. Anyway,
There is a requirement.
what else do you? What do you?
There is a requirement for GPS. He does have a place to stay, so you can kind of confine him.
Where was he on this? You didn't have a place to stay on November 1st?
House.
From across the street.
Anything you want to have on why he was lurking around at midnight? I can't tell. It doesn't say what he was up to, but it obviously frightened the people who were there.
Well, the way I read the PC, Judge, was that there was a sensor outside that picked him up outside.
Yeah, a Ring camera.
Right, going through the yard.
Uh, in the backyard.
Mhm.
Or is this a gated area? Enclosed backyard? I don't know. It says-
Doesn't say.
Two males.
Mhm.
One of them was armed with a firearm. Doesn't show who it is. It doesn't say. Authentic is. Somebody from the house, I guess, confronted them while attempting to get them to leave the property. The shirtless man with the large 59 tattoo on his chest pointed the firearm at the victim. Is that you? Do you have a
59 tattoo?
Do you have a tattoo?
It's hard here. Do you have a 59 tattoo?
Yes, sir. We was in Columbia State, they know me, that's crazy. It was it was like,
No, according to this, he threatened to shoot the other guy. Well,
That's how I read it as well.
yeah, nobody, and when at midnight, when somebody's in your backyard threatening to shoot you and has a gun in their hand, you're not gonna negotiate a truce. You're gonna flee for your life. Oh, that doesn't sound good. And the prior, six, not five, but six prior burglaries of habitation.
Oh, that was 25 years ago, good.
I was a kid, made a
Just a
mistake,
kid.
and I got to my son.
Come here. There's a famous saying, a very smart man said this. What's in the past is never really ever in the past. It's always there. It's still there. Even though it was a while ago, it's still there and it plays a part in this because even 25 years ago, this will increase your punishment. It's still used. It's not too old to be thrown in the trash. It's still going to be part of this case. So that's why I tell people, don't commit crimes because the past comes back to haunt you. Right. Yeah. What are we gonna do?
I'd ask that if you would consider 75,000.
What's that say? It's
I will, of
300,000
course-
right now?
Right. I would, of course,
And he has a GPS device and you can put confinement at home.
I would defer to the court. However, I just would like for you to consider the safety of the community.
I-
The guns is used.
I always will.
And-
What do you suggest?
I suggest that the bond amount, I mean, I'm gonna defer to you, be reduced to no more than $100,000 or $150,000, whichever you feel is just,
100 or 150?
150 with an ankle monitor, of course. But it disturbs me that a gun was used and he allegedly threatened the homeowner to shoot the
I'm
homeowner.
gonna chop it in half to 150,000 plus a GPS. It's his criminal history and the circumstances of this offense are
You wouldn't consider
Disturbing.
100.
disturbing.
Her first try, 100,000. Good.
It's up to them.
Actually, I was,
A position of a.
I mean, if you could read my mind, it was 150. I thought I would chop it in half,
Mhm.
but where are you going to live if you get a bond? Where do you live?
Where you gonna live?
Going to live with me and the kids, I took care of the kids,
How old are your kids?
17, 12, 10.
Oh, yeah, you got children?
Work, yes, sir.
What are you doing at midnight with your children or at home? You're in the wrong place at the wrong time?
And from my bar.
Well, it ended up in an indictment. Oh, you got children at home. Come on. You got important responsibilities.
One mistake can lead to this.
Sir, there are 7 mistakes in here. 7. 6 prior convictions, and then this one. Come on. This is 7. You gotta stop making mistakes that get you in this room. Oh, what's the next event?
Finish up the
Announcement.
recovery, Judge, and then
Okay.
an announcement.
4 weeks
That's fine, Judge. I have another matter.
with him?
Yes.
Go ahead.
His wife or his girlfriend has his hearing aids.
Okay.
And I can't communicate with them except yelling like, so everyone can hear me in jail.
Yeah, I understand. What do we need to do? What can I do?
I think if I can submit a court order, that I can tender those hearing aids with that court order to the jail, they can inspect them or do whatever so that he can get the
Okay.
hearing aids, so I can
Communicate.
communicate and defend my client. No, they're with the girlfriend, right?
Or what?
Wife, common wife.
How long have you been wearing hearing aids?
2 years now.
Okay.
He worked at a plant and
Where plants 18 years, 19 years, so I became a victim of that hearing aids.
Okay.
so if I submit an order to you, allow me to
Yeah.
defend them.
Yeah, yeah. The right to an attorney isn't effective if he can't hear.
You firsthand, Judge.
What'd you say?
You understand me?
Put it loud and clear.
Yes, Your
Anything else? I'll do that.
And you'll reduce their bond down.
150,000 plus GPS device.
Yes, Your Honor.
Thank you.
Thank you.
And don't commit any crimes. If you get out, don't commit any more crimes.
So
We'll set this in 4 weeks. Anything else? That's all, Tom. Thank you.
Thank you, Your Honor.
Anything else?
Judge, can I reapproach on Wiggins?
What do you want to do?
Is, I was able to discuss my options with him, and he's saying he wants to voluntarily be true. And have you assess.
Okay, I just.
It's right, that's fine, if you want to do it, you want to reset it a week.
No, can I do it tomorrow?
What about Wednesday? I'm here Wednesday afternoon.
Wednesday. We're gonna reset Wednesday.
Wednesday afternoon.
Okay, 'cause I've got a meeting I've got to go to right now.
Okay.
It's the same.
But we'll bring Wiggins back and
Wednesday.
move on that. All right, is there an agreement with the state? or-
There was an offer, but he seems to want to go unagreed and put true.
Okay, I'll do
Make
that.
sure that he understands all of his options on the record, and then we'll do it Wednesday.
Okay,
Thank you.
All right, we're gonna recess until
1:30.
1:30.